My lord, with the consent of my lord, I beg to mention item number 53 of supplementary list, my lord.
53.
My lord, due to my personal difficulties, my lord, I could not prepare the keys, my lord. So kindly after the whom, my lord, possibly kindly fix a date, my lord, if possible in the first week of May, my lord.
Mr. P. Khatonia.
No, my lord, K. Sinha. Item number 53.
Is enough for.
Appellant, my lord.
Oh, sorry. Heard Mr. K. Sinha, learned counsel for the appellant, who prays for an adjournment due to personal difficulty. He submits that he has informed learned counsel for the respondent regarding his prayer for adjournment, who does not have any objection to the said prayer. Hence, the prayer is allowed. Let this matter be listed.
My lord, if possible, the first week of May, my lord.
No, 23rd June.
My lord, my lord, myself for item number 40 and 42, my lord. My lord, I am out of station, my lord, so the records file is not in my hand, so I cannot submit today. So, my lord, can it be fixed in another date, my lord? Item number 40 and 42, my lord.
40 and 42 on request of learned counsel for the applicant.
BR Das, my lord.
This Mr. B.R. Das, the learned counsel for the applicant. And the appellant, this appeal is adjourned for the day.
22nd.
No fixed date. Let the same be listed after 4 weeks, after 2 weeks, or date to be fixed by registry.
Yes, my lord.
Yes.
And item and item number 42 also, my lord. I am respondent for item 1 to
Yes,
4.
done. Yes.
May it please the lordship. My lord, I'm praying for a listing of 2 IAs, my lord, for withdrawal, my lord. If possible, my lord, tomorrow, my lord.
Okay.
Deep level.
Alia, please.
Lordship, I beg to mention item number 51, Lordship. I have taken the consent from the other side, Lordship. Engaged counsel having difficulties, Lordship, may adjourn the matter and may fix it on 25th of May, Lordship. 51.
Lordship, I am for the respondent. Kindly matter may fix first week of May.
First week of
25th, Lordship.
item number 51. Heard Mr. What is your name?
M. Alam, Lordship.
M. Alam, learned counsel for the appellant, who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the appellant. Also heard Mr. R.K. Mohanto,
Respondent.
learned counsel for the respondent, who does not oppose the said prayer. Hence, the prayer is allowed. Let this matter be listed.
23rd June.
23rd June.
Lordship, there is some urgency because payment yet to be payment, full payment. So kindly fix it on May month of.
May 3rd.
25th.
11 June.
Lordship. Oh, please.
Lordship, with the consent of the other side, I beg to mention item number 50, Lordship.
Lordship, I am appealing for resolution number 1, claimant, Lordship. Let the matter be listed in the month of April, any date, Lordship.
Then we will not give the date. Registry we can give date only in the month of June. Otherwise, let the registry fix date.
Then
Heard Mr. K.K. Bhatta, learned counsel for the appellant, who prays for an adjournment on the ground of personal difficulty. Also heard Mr. M. Talukdar, learned counsel for respondent, who does not raise any objection to the said prayer. The prayer is allowed. Let this matter be listed after
Lordship, date may be given.
23rd of June.
The claimant has been suffering. It's a case of disability.
No, then let the registry fix the date.
Lordship, then date may be fixed.
27th of June. 23rd of June.
May it please your lordship. Lordship, I am praying for listing of this LA appeal, lordship, in the admission column, lordship. Appellant is aged about 96 years old, lordship.
27th April.
Okay.
May it please, your lordship. Your lordship, I beg to mention item number 50. We will file IA, your lordship.
Item number?
15, your lordship. MSc appeal, your lordship.
Yes.
We will file an IA, your lordship, so kindly matter may be taken up with the IA, your lordship.
Heard Mr. What is your name?
AB Dutta, your lordship.
Heard Mr. A.B. Datta, learned counsel for the appellant who submits that the appellant intends to file an interlocutory application and prays that this appeal may be listed along with the said interlocutory application. The prayer is allowed. Let this matter be listed after 2 weeks on a date to be fixed by registry.
Much obliged.
May it please your lordship, I beg to mention item number 22, 23, 24, and 25, along with 38 and 39. Taking consent from the other side, I beg for adjournment.
22,
22, 23, 24, and 25. 38 and 39.
what is your name?
A Dev, on behalf of DRT.
You are for,
Your lordship,
on behalf of whom?
D Rathi,
Okay.
your lordship for the respondent.
Okay. Heard Mr. A. Deb, learned counsel, submitting on behalf of Mr. D. Rathi, learned counsel for the appellants, who prays for an adjournment on the ground of personal difficulty of the conducting counsel. He submits that he has informed learned counsel for the appellant regarding his prayer for adjournment, who does not have any objection to the same. Hence, the prayer is allowed. Let this matter be listed on 25th of May.
Much obliged. Please, your lordship. Your lordship, with the consent of the other side, I beg to mention item number 10. I'm appearing for behalf of the appellant. The conducting counsel, your lordship, comes from out of station. Today he could not come due to some personal inconvenience. So if a date will be fixed, your lordship, on the first week of May.
Heard Mr. What is your
M.
name?
Shah, on behalf of SC Biswas.
M. Shah, appearing on behalf of
Appellant.
Mr. A.C. Bishwas, learned counsel for the appellant who seeks an adjournment,
Lordship, I'm on same case, I'm on behalf of respondent.
seeks an adjournment on the ground of personal difficulty of the conducting counsel for the appellant. Also, Miss
D Dash,
D. Das appearing for,
on behalf of NN Shah, appearing for respondent number 1 and 2.
appearing for respondent number 1 and 2. Who you don't have any objection,
No.
who does not have any objection to the prayer. Hence, the prayer is allowed. Let this matter be listed on 29th of May.
Obliged.
My please, your lordship, I beg to mention for a listing of a testamentary appeal, lordship. Lordship, after finding the delay of the 220 days, lordship.
Admission column,
No, lordship, it is in admission column for lordship.
admission column, 27th April.
May it please the lordship, I beg to mention for listing of an MC appeal in the admission column.
29th April.
Obliged.
May please your lordship, I beg to mention item number 28 and 23 lordship, 32 lordship. My senior mother-in-law expired yesterday lordship, and the matter may pass over for the day lordship.
28 and
32,
who is your senior?
Didi Baman.
Heard. Miss, what is your name?
P. Sutia.
P. Sutia, learned counsel for the respondent. You have informed the other side. You have to inform. We'll allow your prayer when the matter is called. If it does not reaches in the first half, you may make mention at 2 after informing the other side.
Please your lordship, I beg to mention for listing of an MSc appeal and 2 IA for orders.
Orders. 24th April.
May please, the lordship, I would like to mention item 48, not mentioned as taking a time, lordship. We have taken steps, so it will be for await service report only, lordship.
48.
Yes.
We will pass orders when the matter is called. Even if you are not present, we'll show your presence.
Highly obliged.
Daily list, motion BA, item 1.
My lord, let the TCR be called for after 4 weeks.
Heard Mr. M. Vishwas, learned counsel for the petitioner, also heard Ms. N. Kakoti, learned counsel for DRI. Perusal of the scanned copy of the trial court records would be necessary. Hence, call for the scanned copy of the trial court records along with the scanned copy of the connected case diary. Charge sheeted case.
Yes, ma'am.
Connected case diary. Let this matter be listed. 22nd May. Why it has been listed before?
Second.
22nd May.
In the meantime, they may file their objections.
Lordship.
Yes, the respondent side may file their objection if they do so desire to before the next date fixed.
I'm deeply obliged.
Obliged.
Item 2.
This subsequent bail application, Lordship, may kindly see page 20 is the first order. Page 20. Here, Lordship, 6 persons approached before this honorable court, and your Lordship was pleased to grant bail, except petitioner number 4 and 5 reflects in page 20. So thereafter, Lordship, they again filed one bail application, that your Lordship will find page 25. This Saiful Islam and Saddam Hussein, they both filed application, and your Lordship was pleased to reject after perusal of the case diary. Now, I am coming up, renewing my prayer for bail on the ground that Lordship, that Saddam Hussein, he surrendered before the court after rejection of that bail application. And during that period, Lordship, may kindly see page 29. Page 29, one report was called status report from the IO, and it reflects that, page 20, may I read? Lordship?
Page 29.
Yes.
Yes.
Call for status report of this case has been received. In the said report, it is reported that the investigation of the case almost completed, and now it is only pending for arrest of absconding accused Saiful Islam. So investigation is probably completed, Lordship. On that ground, I am renewing, Lordship, may call for the case diary and may examine the issue, Lordship. And already as per my instruction, Lordship, that other co-accused, he has.
No. But when your prayer was rejected on earlier occasion,
Lordship.
what is the ground?
On merit, your Lordship, that your Lordship will find page 27. Paragraph 8.
Yes.
I have considered the submissions made by the learned counsel for both sides, and I have gone through the case diary of Goromari PS so on earlier occasion. The prayer for anticipatory bail of the petitioner was rejected on the ground that there were sufficient incriminating materials against both the accused persons. In the meanwhile, some more witnesses have been examined, and there are sufficient incriminating materials against the petitioners in the case diary, which do not justify allowing them to go on anticipatory bail at this stage. Accordingly, the prayer for anticipatory bail of the petitioner stands rejected at this stage.
But already materials are there against you.
Now the investigation is almost complete. Whether further custodial interrogation will have any way the
No, but this is a case under 103.
Lordship. It is there, Lordship. But now, Lordship, after that, the investigation has progressed further. So only for case diary, Lordship will see whether anything is there or not.
Moreover, victim has also implicated, Lordship. It is there in the rejection order, Lordship.
And apart from
We
that,
are implicating the.
What is your new ground?
another ground is that, Lordship, that the co-accused who surrendered before the court, he took the plea that he assaulted the victim during self-defense, Lordship. That I have taken a specific plea, Lordship. So the Lordship will verify that aspect, Lordship. That is the knowledge of the present petitioner. Page 6, Lordship.
Okay.
will find-
Already been,
Page 6.
Lordship has already been produced. Let's see, all these things has been looked
But
into.
now
Lordship.
Saddam Hussein was in custody, who is one of the accused. And if he says that he assaulted the victim at that during self-defense, Lordship, that probably will exonerate the petitioner if it is true, Lordship.
Lordship, it will be come up in the trial stage, Lordship, not at this stage, Lordship, bail petition.
What is the evidence against you?
Evidence against you that the present petitioner and Saddam Hussein assaulted the victim. Lordship.
Stated by the victim, Lordship.
That is the evidence.
Then you don't have a case.
Lordship.
At this, the Lordship may call for the case because if Saddam Hussein stated a different facts, that may Lordship
Okay.
make out a case. for
Heard.
the-
Mr. A. Ahmed, learned counsel for the petitioner, also heard Mr. K. Das, learned additional public prosecutor. This is for the third time the petitioner has approached this court seeking anticipatory bail. On earlier two occasions, the anticipatory bail application filed by the present petitioner was dismissed. Learned counsel for the petitioner has, however, submitted that in the meanwhile, one of the co-accused, namely Saddam Hussein, has surrendered before the court, and in his statement made before the investigating officer, he has stated that he assaulted the victim in an act of self-defense. In view of this said statement, learned counsel for the petitioner submits that since the investigation has progressed fairly and almost completed, the case diary may be produced so that in light of the new evidence collected by the investigating officer, the petitioner may not be required for custodial detention. Let the case diary be called for. When
27, Lordship.
let this matter be listed on
27, Lordship.
27th of
April.
April.
Obliged.
Hearing BA, item 16. Item number 16.
We'll take it up later on.
Criminal matter orders, item 35. Admission, item 3.
Wait, please, your lordship. Your lordship, my senior is on legs at code number 10, your lordship. So kindly take this matter after some time. My lord.
Just a minute.
Oh, good.
Yes, what is the matter?
Regarding guardianship, my lord.
Regarding guardianship, your lordship, custody of the child.
Okay, we'll take it up after some time.
Obliged.
Item 4.
Wait, this is your lordship. This is a MFA lordship. The substantial question of law I have mentioned, my draft substantial question of law at page 7 of my memo of the lordship. Lordship, here the employer-employee relation is not proved because the owner never appeared. It's a company lordship. And the deceased died due to electrocution, not involving the vehicle like an accident.
Where is the substantial
Page
question?
7, lordship.
Page 7 of the memo.
Memo of appeal, lordship.
Why electrocution cannot be, person dying due to electrocution cannot be compensated?
First of all, there has to be an employer-employee relationship. In the documents that were exhibited by the claimant, Lordship, by the claimant, no document is exhibited that he was employed in that vehicle, Lordship. That Lordship, the exhibited document are at page 13 of the judgment, Lordship. The first question is that employer-employee relationship. In electrocution, Lordship, vehicle has to meet with an accident. That is the coverage. Electrocution will be ACB's issue, Lordship, not of the vehicle. Vehicle did not meet with an accident. Page 13 are the where
If vehicle is electrocuted,
then ACB is because that is the negligence of the
but cannot be not said that vehicle met with an accident.
no, Lordship, how can it was a standing vehicle, it was electrocuted, then
That is an accident.
that
Yes.
Lord, the last appeal, my land to have to furnish the copy of the appeal memo. My lord, it is not a sharp upon me at that time, my lord.
Lordship, I can serve it. This is for admission. No issue. I forgot, Lordship. I apologize to
We are framing one substantial regarding perversity.
Lord, at this stage, my lord, if the matter may be admitted, my lord, 50% amount may be deposited, my lord, subject to be.
No, not for admission.
It may be admitted, my lord. then.
That may be a condition for stay. But heard Miss R.D. Majumdar, learned counsel for the appellant, also heard Mr. Yes,
नाम तो कोई दो।
F.A. Hassan, learned counsel for the respondent. Respondent number?
1.
Respondent number 1. This appeal under section 30 of the Employees Compensation Act 1923 has been preferred by the Oriental Insurance Company Limited, impugning the judgment and award dated 19/8/2023 passed by the learned Assistant Labor Commissioner, Commissioner for Employees Compensation, Nagaon, in NEC case number 17/2022, whereby the appellant was directed to pay a compensation amount of rupees 16,75,325, along with an interest at the rate of 9% per annum to the respondent number 1. I have gone through the memo of appeal and have considered the submissions made by learned counsel for the appellant. On the basis of materials available on record, following substantial question of law is formulated in this appeal. Whether the learned commissioner, employees compensation Nagaon committed perversity in passing the impugned judgment without taking into consideration that the employer's-employee relationship of the deceased and the owner of the offending truck was not established in this case. Further, whether the Commissioner Employees Compensation Nagaon committed perversity in treating the act of electrocution of the parked vehicle as an accident for grant of compensation under Section 3 of the Employees Compensation Act 1923. Stop. Let the records of NEC case number 17/2022 be called for from the Office of the Commissioner, Employees Compensation, Nagaon, Assam. Registry to take steps for requisitioning the records. Since Mr. Hassan has appeared for respondent number 1, no formal notice need to be issued to the said respondent. However, the appellant is directed to furnish the copy of memo of appeal along with annexures to the learned counsel for respondent number 1 within 2 days from the date of this order.
Lordship, any other substantial question of law at the time of hearing?
There is no,
Okay. No issue.
and that power is always there,
Yes.
even if it is not mentioned.
But some courts like Lordship.
If you can point out, we will frame.
Fine.
Issue notice to respondent number 2. The appellant shall take steps for issuance of notice upon respondent number 2 by speed post as well as by usual mode within 7 days from the date of this order, returnable on 25th of May.
For admission.
25th of May. No, if we have already admitted it.
Then insurance company.
You have IA.
Aye.
IA, you pay 50%.
Yes, madam.
Lordship, we can deposit, but let them file a petition because there will be some hearing will be needed. Lordship.
Okay.
At least the employer-employee relation, McKinnon-McKenzie judgment is there, Lordship. So
Okay.
we may be directed to deposit.
Heard Miss R.D. Majumdar, learned counsel for the applicant. This interlocutory application has been filed by the applicant insurance company in connection with MFA number 16/2025, praying for stay of execution of the impugned judgment and award dated 19/8/2023, passed by the Commissioner, Employees Compensation Nagaon in NEC case number 17/2022, whereby the applicant was directed to pay a sum of rupees. How much?
16,75,325
To the
with 9% interest.
claimant respondent. You file an application
Yes, madam. We'll
since learned counsel for the claimant respondent, opposite party number 1 has not opposes the prayer on the ground that 50% of the awarded amount may be directed to be deposited by the applicant. And since he submits that the claimant would be filing a separate application for allowing the claimant to withdraw the same, the notice to respondent number 2 is waived, and this this interlocutory application is allowed. The Impugned judgment dated 19/8/2023, passed in NEC case number 17/2022 by the by the Commissioner, Employees Compensation Nogao shall remain. No, the execution of the impugned judgment shall remain stayed during the pendency of the connected MFA number 16/2025, subject to deposit of 50% of the awarded amount by the applicant before the registry of this court within a period of 4 weeks.
6 weeks, Lordship.
6 weeks from the date of this order. The claimant may file a separate interlocutory application for withdrawal of the same as desired by learned counsel for the claimant. This interlocutory application is accordingly disposed of.
I'll apply to it.
Please, Your Lordship. So in this case, the substantial questions of law are on page
Page number?
page 8. So this is was a driver. And in the claim petition, his wages was claimed as 10,000. Without amendment of the claim petition, Lordship, it is considered as 15,000. That is, it gives rise to a substantial question of law. And a penalty was also imposed, Lordship.
Where is this page number?
Page number 8, Lordship. Of the memo.
Yes. What is your submission regarding penalty?
Penalty, Lordship, is not insurer's liability, Lordship. Under the provision is a settled position of Lordship, insurance company is not liable for penalty. It is judgment of the Supreme Court to the effect. Process premium.
Yes, Mr.
Subject to payment of 15.
Okay, heard Mr. R. Goswami, learned counsel for the appellant. Also heard Mr. M. Khan, learned counsel for respondent number
1 to 4.
1, 2,
4. 1, 2, 3, and 4.
1 to 4. This appeal under section 30 of the Workmen's Compensation Act 1923 has been preferred by the appellant Messrs. Liberty Videocon General Insurance Company Limited, impugning the judgment and award dated 6/11/2024, passed by the learned Commissioner, Workmen Compensation, Bongaigaon in EC case number 9/2020. I have considered the memo of appeal. I have gone through the memo of appeal as well as considered the submissions made by learned counsel for the appellant. After considering the materials available on record, following substantial question of law is formulated in this appeal. Whether the impugned judgment and award passed by the learned commissioner, Bongaigaon.
May I leave, Lordship?
Yes, yes. Passed by the learned commissioner Bongaigaon is hit by perversity in as much as without any evidence on record, the learned commissioner ascertained the monthly wages of the deceased
Yes, Lordship.
or injured,
This is, Lordship.
deceased at rupees 15,000 per month. And also, and further, though the insurance company is not liable to indemnify the owner in respect of the penalty, the insurance company was also directed to pay the penalty for the owner. Stop. Since Mr. Khan has already appeared for the respondent number 1 to 4, no formal notice need to be issued to the said respondent. You have
Five days owner may not be required. Notice was sent. What is awaited today? I don't know if it is in.
no. This is the first day this appeal has come. When notice was sent?
Lordship, it was actually, there was a delay, continuous delay also, that was.
No, but here you have to send again.
He may not be required, so can I strike him off? Because it's entirely question of quantum.
Learned counsel for the last line. However, the appellant shall furnish requisite copies of memo of appeal along with annexure to the learned counsel for the respondent number 1 to 4. As regards respondent number 5, who is the owner of the offending vehicle, is concerned, learned counsel for the appellant submits that since the grievance of the present appellant is only in respect of the quantum of the compensation awarded to the claimants, the notice to respondent number 5 may be waived. The prayer is allowed. Let the records of EC case number 9/2020 be called for from the office of the Commissioner Workmen Compensation, Bangaigaon. List this matter again on 25th May.
With regard to the granted withdrawal amount, Lordship.
Just a minute. क्या लिखा? List this matter again on 25th May after receipt of order. What is the stay?
50%.
You deposit 50%.
Yes, that can be withdrawn.
Okay. I heard Mr. R. Goswami, learned counsel for the applicant. Also heard Miss, what is her name?
Say Akhtar.
J. Akhtar, learned counsel for the respondent claimant, learned counsel for the claimants / respondent number 1 to 4. This interlocutory application has been filed by the applicants under Order 41/5 of the Code of Civil Procedure, praying for stay of execution of the impugned judgment and award dated 6/11/2024, passed by the Commissioner Workmen Compensation, Bangaigaon, in EC case number 9/2020, whereby the applicant insurance company was directed to pay a compensation amount of rupees how much? Amount of rupees 16,75,275 to the claimants, along with an interest at the rate of 6% per annum. Learned counsel for the claimants respondent submits that the claimants do not have any objection to the prayer, subject to the condition that the applicant may be directed to deposit 50% of the awarded amount, and the claimant may be allowed to withdraw the same. The learned counsel for the applicant submits that said condition is agreeable by the applicant. Stop. Considering the above facts, notice to respondent number 5, opposite party number 5, namely the owner of the offending vehicle, is waived, and this interlocutory application is allowed. The execution of the impugned judgment and award passed in EC case number 9/2020 is stayed during the pendency of the connected MFA number 3/2026, subject to condition that the applicant insurance company shall deposit 50% of the awarded amount before the registry of this court within 6 weeks from the date of this order. Stop. On such deposit, same shall be disbursed by the registry to the claimants, respondent number 1 to 4. After proper verification, this interlocutory application is accordingly disposed of.
Deeply obliged.
Item 6.
This case is a testamentary appeal against the impugned order dated 29/1/2026. Along with that, I have filed an IA, my lord, for reducing the additional evidence. The petition number 1, respondent number 1, 2, 3 are the brothers, and 4, 5, 6 are the sisters, my lord. So here, my lord, the case is, my lord, the will was made by the mother of this brothers and sister, petition number 1, along with the respondents, my lord. The will was dated at 4/2/2013, my lord. Thereafter, the testatrix died on 2016, my lord. Then a miss
When bill was executed?
4/2/2013, my lord. 4/2/2013. And thereafter, the testatrix died on 2016, my lord. The exact date, my lord, testatrix died is the exact date testatrix died 26/12/2016, my lord. Then, my lord, we have filed misprobate case, being misprobate case number 03/2017, my lord. The notices were issued. Subsequently, the 3 brothers, that is respondent number 1, 2, 3, have filed a written statement, and 4, 5, 6, and 7 had given a no objection certificate regarding
The probate case was dismissed.
the probate case was dismissed, my lord. Dismissal grounds is in the impugned judgment, which is at page number 130, my lord. 130.
Okay, we are. No, what are your grounds?
The grounds are that, my lord, since there are several grounds, my lord, because the IA has been filed under section 1071D, order rate with 41 rule 27 of CPC, my lord, 151, because
We will take into consideration later.
because the additional evidence why the grounds were
No, your appeal has not yet been admitted.
yes, my lord, but my lord, because the documents which I have brought in the IA, my lord, that will satisfy the court and remove the doubt, my lord, of this court.
No, that will be subject to condition that your eye is allowed.
My lord, my lord, if my lord may have the impugned order, my lord, first, my lord, the operative part, my lord.
Okay, we are issuing notice. Where are your grounds?
The grounds are from page number, my lord.
Why it was dismissed? You failed to.
But there is 2 grounds which has been dismissed, my lord, dismiss the probate application, because one, the mother used to sign in Bengali, my lord, but we have, the mother had put the thumb impression. The other thing is that the legal requirement of under section 68 has not, 63, 5 was not proved that one attesting witness the testator had signed that in front of one attesting witness, my lord. But my lord, in evidence, we have state that, yes, it was signed in the presence of the attesting witness. My lord, may come to the page number 38, my lord. My lord,
Okay. Third, Mr. A.R. Barua, learned counsel for the appellant. This appeal under section 299 of the Indian Succession Act 1925 has been filed by the appellant Shri Ashut Chakraborty, impugning the judgment and decree dated 29/1/2026, passed in title suit within bracket probate number 2/2022 by the Court of London District Judge Dibrugarh, whereby the probate application filed by the present appellant was dismissed. I have gone through the grounds taken by the appellant in the memo of appeal and have considered the submissions made by the appellant. This appeal is admitted. Issue notice to the respondents and call for the records of title suit within bracket probate 2/2022 from the Court of London District Judge Dibrugarh, registry to take steps for requisitioning the records. Issue notice to the respondents. The appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 25th May. In IA also issue notice. Same order.
May it please you.
Yes.
Well, it's appeal under section 30 of the ECA. My lord. The substantial question of law, my lord, we have formulated. When I frame at, my lord, page 4, my lord. So for mere fracture injuries on his right leg, my lord, 40% disability was assessed. And look, it's fine. Order is there, no? It's a copy. And my lord, the same driver, my lord, he was found again, my lord, injured in a different accident after 2 months. He was driving another vehicle, my lord. That GT extract also, my lord, we have tried to bring it, my lord.
No, this disability was assessed on the basis of
Examination.
doctor.
Yes, ma'am.
Then where is the
My
perversity?
lord, on the, after 2 months, the accident happened in the, where's the, give me the, this thing? On 5/10/2003, the accident had occurred. And after 2 months, my lord, in December 2003, he again was driving a truck and he met with another accident, my lord. And a different claim was lost by him. That.
So what you want to say?
Well, he didn't have any disability. He being the driver, my lord, fracture injuries, they were cured. So he was driving another vehicle, my lord. And the claim has been filed after 2 months. And that GT extract, my lord, we have brought it on record also, my lord, by order 41/27 application.
Before the
My lord, before the commissioner, my lord, that was not executed. As such, my lord, we have brought it on record by filing a separate IML.
no, that will be taken into record
Yes,
only.
my lord, when the hearing. So at best, my lord, the assessment could have been done under 41D, my lord, not 41C.
What is 41D? employees compensation.
PC Act. My lord, had my lord got it.
Yes,
My lord, where temporary disablement, whether total or partial, results from the injury. A half monthly payment of the sum equivalent to 25% of the monthly wages of the workman to be paid in accordance with the provision of subsection 2. Now, my lord, if your lordship comes to subsection 2, the half monthly payment referred to so and so
okay,
shall be paid on the 16th day from the date of disablement, where such disablement lasts for a period of 28 days or more.
okay. Heard,
After, my lord,
heard Mr. R.K. Patra, learned counsel for the appellant. This appeal under section 30 of the Employees Compensation Act 1923 has been preferred by the National Insurance Company Limited, impugning the judgment and award dated 6/3/2023 passed by the Commissioner, Employees Compensation Knockout in NEC within bracket WC case number 238/2003, whereby the present appellant was directed to pay a compensation amount of rupees 2,06,668 to the claimant, along with an interest at the rate of 9% per annum. After going through the memo of appeal and after considering the submissions made by learned counsel for the appellant, following substantial question of law is formulated in this appeal. Whether the judgment and award impugned in this appeal is hit by perversity, inasmuch as the Commissioner Employees Compensation Nagaon granted compensation to the claimant under section 4(1)(c), 4 within bracket small 1, 4(1), just 4 within bracket 1 within bracket small c within bracket small Roman 1, 2 of the Employees Compensation Act, taking the disability to the of the claimant to the extent of 40% for mere fracture injuries suffered by him. Issue notice to the respondent and call for the records of NEC within bracket WC case number 238/2003 from the Office of Learning, Commissioner Employees Compensation Account, registry to take steps for requisitioning the records. The appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 25th of May.
they are separate two IAs. One is for stay and one is for order.
We'll issue notice.
My lord.
In IA also issue notice.
Stay.
Both IAs, stay as well as 27 petition issue notice.
My lord. Item 8.
May it please your lordship, in this matter, as per the office note dated 27/3/2026, service is not complete, your lordship, and TCR is yet to be received, your lordship. So kindly a date may be given, your lordship.
Heard, Miss, what is the name?
C. Murtaja on behalf of Miss R. Chaudhary.
S.C. Murtaja, submitting on behalf of Ms. R. Chaudhary, learned counsel for the appellant. On perusal of the office note dated 27/3/2026, it appears that the notice issued to respondent number 2 has returned without service, whereas one AD card of notice issued to respondent number 3 has returned. The registry is directed to place the postal track consignment report of notices issued to respondent number. Who is one? Respondent number 1 and 3 before this court on the next date fixed. In the meanwhile, the appellant is directed to take fresh steps for issuance of notice upon respondent number 2 by speed post as well as by usual mode within 7 days of date of this order, returnable on 22nd May.
Item 9.
May it pleases your lordship. The substantial question of law I have mentioned at page 8, lordship. First of all, the commissioner has not mentioned under what section the calculation is made of the compensation. Secondly, lordship,
No, he has not mentioned.
Yes.
Okay.
because it has to be, because different kind of compensation of 4.1C to 4.1D, there are different calculations. Calculation has been made. And whether it is prerequisite under the EC Act 1920 to file the relevant documents along with the petition. This substantial question of law I have mentioned, lordship, because lordship, the case was filed in the year 2012. The documents of injury were, disability were of
Where is your substantial question?
page 8, lordship. Judgment in the case was passed after 11 years in 23. Though the case was filed in 2012. And then third is, lordship, the resultant disability will not affect him as per 2G, lordship, in every employment. They have the doctor as well as the claimant has not mentioned, petitioner has not mentioned that the resultant disability will incapacitate him in pursuing every employment, that every word, lordship. And then, lordship, fourth is whether the compensation should have been calculated as per section 4.1D.
No, now under what provision compensation has been?
That is not mentioned. That is why it is,
Can it be treated under 4.1D?
no. 4.1D is, lordship, for maximum 5
Or
years.
it has been done under 4.1C?
C to, yes. But that provision has not been mentioned. Calculation is done as
Or
well.
even if it is not mentioned, if it is apparent from,
Our High Court judgment, in one case I appeared, lordship, in which it was mentioned by Justice Surana that it has to be mentioned, that it is required.
then that is not substantial, that question has been settled.
That the lordship put that question to me also in another case, that
Yes,
if it is
then it
settled,
is-
I'll bring those judgments, lordship. And it is not a question of settled, lordship. that was not settled as substantial question of law. That was mentioned in the judgment that the commissioner has to mention under what provision it is to be given or it is given.
Yes, Mr. Padgiri.
No memo of appeal has been sought, my lord.
Lordship, today it has come for admission. After admission, only notice goes, Lordship.
Heard Ms. R.D. Majumdar, learned counsel for the
अपने
appellant.
phone number to लिख दो.
Also heard Mr. A.R. Padgiri,
Respondent number 1.
learned counsel for respondent number 1. This appeal under section 30 of the Employees Compensation Act 1923 has been preferred by the Oriental Insurance Company Limited, impugning the judgment and award dated 14/7/2023 passed by the learned commissioner, Employees Compensation Nagaon in NEC case number 54/2012, whereby the present appellant was directed to pay a compensation amount of rupees 4,23,459 along with an interest at the rate of 9% per annum to the respondent number 1/claimant. I have considered the memo of appeal, grounds stated in the memo of appeal, as well as also considered the submissions made by learned counsel for the appellant. On the basis of the materials on record, following substantial question of law is formulated. Whether whether under Employees Compensation Act 1923, it is mandatory for the commissioner to mention the provision of statute under which calculation for compensation is made. Question mark. Number 2. Whether the impugned judgment and award of the commissioner of the learned commissioner Employees Compensation Nagaon is hit by perversity in as much as it has not discussed as to whether the claimant was incapacitated from pursuing every employment as a result of disability incurred due to the injury sustained by him in the accident. These two only.
And Lordship, the 4(1)(d), the calculation,
No, that is covered within
the other one.
first one. Since Mr. K.R. Padgiri has appeared for the respondent number 1, no formal notice need to be issued to the said respondent. However, the appellant shall furnish a copy of memo of appeal along with annexures to the learned counsel for the respondent number 1 within a period of 1 week from the date of this order. As regards respondent number 2, is concerned, the appellant shall take steps for issuance of notice upon the said respondents by speed post as well as by usual mode within 7 days from the date of this order. Returnable
Lordship, 10 days, Lordship, because Bihu
within
vacation.
within 10 days, within 10 working days.
Okay.
Returnable on 25th of May. Let also record of NEC case number 54/2012 be called for from the Office of the Learned Commissioner, Employees Compensation Nagaon, Registry to take steps for requisitioning the records.
I'll apply.
Yes.
IA is not there. No.
Item 11. Obliged.
May I please, Your Lordship, this appeal is a statutory appeal against the judgment passed by the learned civil judgment, page number 47. Page number 47, the interim judgment, my lord, the suit is dismissed not on merit, my lord, but on delay ground, my lord. Page number 47. The fact is that, my lord, the plot of land without acquire by the state government had established a, my lord,
Suit was barred by limitation.
yes, my lord, limitation. But my lord, in fact, it is a suit for compensation of the land acquired without following the Land Acquisition Act, my lord, in the long run. And recently, during the period of NRC updation process, they have came across a document of 1958 where the mother of the appellant herein was the patta holder, and she was given a notice in 1958. And subsequently, my lord, without further processing, my lord, of as per land
Whether this appeal was also barred by limitation.
limitation is condoned, my by this
Already condoned.
already condoned.
Okay.
So, my lord, this
Heard
statement-
Mr. M.J. Kadir, Learned Counsel for the appellant. Also heard Ms. J.
M. Kalita.
M. Kalita, Learned Counsel for respondent number
4.
4. Who is appearing for 1 to 3?
Waiting for 1, 2, 3. B. Bora on behalf of Mr. D. Upamanyu.
Also heard Ms. B. Bora, appearing on behalf of Mr. D.
Upamanyu.
D. Upamanyu, Learned Counsel for respondent number 1, 2, and 3. This appeal under section 96 of the Code of Civil Procedure 1908 has been preferred by the appellant, impugning the judgment and decree dated 4/4/2024 passed by the Court of Learned Civil Judge Senior Division Hailakandi in title suit number 66/2023. I have gone through the grounds stated in the memo of appeal and have considered the submissions made by Learned Counsel for the appellant. This appeal is admitted. Let the records of title suit number 66/2023 be called for from the trial court. Since the respondents are represented by their engaged counsel, no formal notice need to be issued to them. However, you have furnished the,
will serve.
however, requisite number of copies of memo of appeal along with annexures may be furnished to the Learned Counsel for respondent number 1, 2, 3 as well as respondent number 4 within 7 days from the date of this order. List this matter again on 29th of May.
Obliged.
Item 12.
May it please your lordship.
Yes.
Lordship, I have preferred this appeal against the impugned order dated 25th of November 25. Lordship, whereby my prayer for ad interim injunction was rejected.
25th of
11/2025, November. 25/11/2025. It's the impugned order is at page number 44, annexure 5.
What is the period of limitation?
Period of limitation
90
90
days.
days, Your Lordship. It's within the period of limitation.
What is the status of the,
The,
is it a title suit?
it is a title suit, Your Lordship.
What is the status of the Ms. J case in which the order was passed?
Ms. J case was, my application was rejected on the ground that, because basically what has happened, Your Lordship, this is
After the Ms. J case has been disposed of,
disposed of,
you have approached this court against the final order.
final order.
Where is the order?
Page number 44.
Okay. Heard Mr. G.R. Datta, learned counsel for the appellant. This appeal under Order 43, Rule 1 within bracket small r of the Code of Civil Procedure 1908 has been preferred by the appellant, namely Rakesh Devnath, impugning the order dated 25/11/2025 passed by the Court of Learned Civil Judge, Senior Division Number 2, Kachar, in Ms. J case number 114/2025 in connection with title suit number 72/2025. Stop. By the impugned order, the application filed by the present appellant under Order 39, Rule 1 and 2 for grant of temporary injunction during the pendency of the connected title suit was rejected. Let the notice be issued to the respondents and let the records of Ms. J case number 114/2025 as well as scanned copy of the records of title suit number 72/2025 be called for from the trial court. Registry shall take steps for requisitioning the records. The appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on.
Your
20.
Lordship, I have a submission to make. Along with this appeal, I have preferred an application under Order 39, Rule 1 and 2 for granting ad interim injunction, which was dismissed. Your Lordship, I have valid grounds. If I am given an opportunity, I want to place before Your Lordship certain facts which
Short date due. April or last week. 30 April. We are issuing notice in that case also. We are giving.
because Your Lordship, what has happened with I'm taking the lead.
Let the notice be served.
Because if in the meantime, if they carry on with the auction, Your Lordship, what will happen is that my right title interest, which I'm a bona fide
No.
purchaser subsequently.
After hearing you, both the side trial court has dismissed or.
Your Lordship, the trial court has not taken into consideration the.
So
point
without
that-
hearing the other side, you are not getting interim. Therefore, we are fixing a short date. In I also issue notice fixing 30 April.
Deeply obliged.
Item 13.
This is regular first appeal, my lord, rise out of the judgment passed in the title suit, my lord. The petitioner were, my lord, defended, my lord. And my lord, ground of my lord appeal is the plaintiff here in the respondent number 1. There is no positive prayer for right title and interest. Only negative prayer that I have no right title and interest. And my lord, this for recovery of possession, my lord, which is my lord, bar by section 65 of the limitation act. Because my lord, after 20 years of my lord, later the possession, prayer for possession of recovery is there, my lord.
What was the decree?
Decree, my lord, declaration and recovery of possession.
What was your plea?
My
Whether
plea-
you took the plea of adverse possession or you are claiming right title?
I, my lord, filed a counter claim, my lord. And my claim was that I purchased the land.
Purchase,
Yes.
but you failed to prove.
But my lord, my counter claim dismissed. And my lord, that suit of the plaintiff, my lord, decreed. My lord,
Okay, heard Mr. S. Chauhan, learned counsel for the appellant. This appeal under section 96 of the Code of Civil Procedure 1908 has been preferred by the appellants, impugning the judgment and decree dated 16/2/2026, passed in title suit number 7/2022 by the Court of London Senior Division, Civil Judge Senior Division, whereby the you were plaintiff.
No, my lord, I was defendant. Both are were defendant.
Suit was decreed or dismissed.
Suit was decreed.
But in your you look at your cause title of the memo of appeal. What have you written?
My lord, an appeal under section 96 of the order 41 of the Civil Procedure Code against the impugned judgment and degree dated passed in title suit number 1 by learned civil judge. They'll be dismissing the suit. My lord, I am against the dismissing the suit.
But you are saying that suit was decreed.
My lord, it is this word is, my lord, it is wrong, my lord. It is actually against decree.
You rectify it.
Yes, my lord. Absolutely.
Decreeing the suit of the plaintiff and dismissing the counterclaim filed by the present appellants. I have gone through the grounds stated in the memo of appeal. This appeal is admitted. Issue notice to the respondents and call for the records of title suit number 7/2022 from the Court of London's Civil Judge Senior Division of Dalgori. The registry shall take steps for requisitioning the records. The appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 29th of May. List accordingly.
My lord, I pray for a stay of decree, my lord.
Any execution case has been filed?
Not filed, my lord, but is meant to be filed, my lord. We have heard.
No, you answer my query.
No, not yet filed.
Not yet filed. So we are issuing.
They are observing, my lord, the statutory period of appeal. Perhaps that is
We are issuing notice. I also issue notice. Same.
Item 14.
Please, Your Lordship. Lordship is a statutory appeal under section 96 of.
Heard Mr. What is your name?
P. Borua.
Heard Mr. P. Borua. You were plaintiff or defendant.
Plaintiff, Lordship.
Your suit was dismissed.
Dismissed ex parte, Lordship.
Dismissed ex parte.
Lordship. Considering we have asked for title by virtue of our adverse possession, but they considered us as a permissive occupier and dismissed the suit.
This appeal under Order 41, Rule 1 of the Code of Civil Procedure has been preferred by the appellant, Shri Raktim Saikia, impugning the judgment and decree dated 23/9/2025, passed by the Court of London, Civil Judge Senior Division, Jorhat, in title suit number 43/2024, whereby the suit filed by the present appellant was dismissed. I have gone through the grounds stated in the memo of appeal and have considered the submissions made by learned counsel for the appellant. This appeal is admitted. Let the records of title suit number 43/2024 be called for from the trial court. The registry shall take steps for requisitioning the aforesaid records. Let also notice be issued to the respondents. The appellant shall take steps for issuance of notice upon the respondent by speed post as well as by usual mode within 7 days from the date of this order, returnable on 29th of May. For rectification, you have to know there is a recent notification that for rectification you have to file amended cause title. So follow that notification.
Item 17.
May I please, your lordship?
Then yes.
Lordship, in this case, service is complete and for respondent number 1, insurance company has entered appearance. But in this case, lordship, LCR is not called for.
Not called for.
Yes.
Reminder should go by.
What is your name?
SP Das.
Heard Miss S.P. Das, learned counsel for the appellant. Also heard Miss S.L. Sharma. Yes.
Let me withdraw my apartment in this case because mistakenly I was also appointed by the same respondent number 1. So let me withdraw my apartment.
Okay.
My name also shown there.
Heard me. Also heard Miss L. Sharma, learned counsel for the respondent number 1. Mr. P.J. Soikia.
Borman.
Sorry, Mr. P.J. Borman, learned counsel for respondent number 1, who submits that he has also filed wakalatnama for respondent number 1. However, since Ms. L. Sharma is appearing, he may be, in this case, for respondent number 1, he may be allowed to withdraw his wakalatnama. The prayer is allowed. The name of Mr. P.J. Borman need not to be reflected as engaged counsel in for the respondent number 1, comma, in the cause list, comma, henceforth. Other respondents, as regards other,
Service is complete, lordship. Lordship, respondent number 3 has been struck off and 2 is considered to be served upon, lordship.
when? Where is the order of service on 2?
6/3/2025 26 and 9/2/26, Lordship.
No, there is no indication. Who is to?
Who is the owner, I think, my lord.
No,
Owner. Owner also.
Lordship, kindly peruse office note dated 19/1/2023 regarding respondent number 2.
On perusal of the office note dated 19/1/2023, it appears that the notice which was issued to respondent number 2 was received back with an postal endorsement within bracket refused. As such, the notice issued to respondent number 2 is held to be duly served. Let the records of MEC case number 783/2012 be called for from the Motor Accident Claims Tribunal number 2, Kamrup Metro, registry to take steps for requisitioning the aforesaid records. Let this matter be listed 15th of May. Yes.
Lordship, and for the appellant, Lordship, the respondent number 1 was to give the details of the deceased person to them.
Who died?
Respondent number 1, Lordship.
Who was the counsel?
Counsel, my lordship. Namely one A. Ahmed.
A. Ahmed is for who will give you the when respondent number 1 himself has expired? You contact the counsel for respondent number 1, Mr. R. Fukun, and take the details.
Yes, my lord.
Heard, Miss, what is your name?
M. Chetia.
M. Setia, learned counsel for the appellant, who submits that by order dated 12/3/2026, the counsel for respondent number 1 was directed to furnish details to the appellant regarding the death of respondent number 1. However, same has not been furnished. Learned counsel for the appellant submits that she may be granted some time so that she may contact the learned counsel for respondent number 1, namely Mr. R. Fukon / R. Mohanta, and take the necessary details therefrom, and thereafter take necessary steps in this regard. The prayer is allowed. Let this matter be listed. 8th of May.
Item 19 and 20.
Lordship, in item 19, there is 38 days delay. Lordship, in page number 4, the reasons for delay, Lordship, it is mentioned from para 7. Roman 1 to Roman 4, Lordship.
Whether appearance, respondent number 1 and 2 are appearing.
Item 20 is appearing, Lordship, for respondent number 2.
And in 19?
No.
They are different persons.
I do not know. 19, I have not see. 20, I am appearing for respondent number 2, that is the owner.
What is his name?
19 or so. Manju De.
Manju Day. Here also Manju Day is the respondent number 1. You can appear for.
Taking the instructions on the
You seek instructions. Let them seek instructions.
Just from they are residing at West Bengal. So
We'll give you time. Heard Mr.
Ali.
A. Ali, learned counsel for the applicant.
Lordship, delay may be convened, Lordship.
No, just let the appearance be complete. Yeah, they even don't know. Let him take instruction. You have not taken steps for issuance of notice.
Lordship, for item number 9.
Item number 19, have you taken steps? But office note says that you have not taken steps.
take steps, Lordship, because
when have you taken steps?
Lordship. You don't have a Lordship.
Where is the acknowledgement? When you submit notice in the filing section, you are furnished with an acknowledgement receipt.
Lordship, you have not received, Lordship.
Where is that acknowledgement?
Lordship, not received.
Not received? That cannot be if you have.
Lordship, actually, I was not there, Lordship.
You take fresh steps. In the meanwhile, let him take. On perusal of the office note dated 10/3/2026, it appears that the petitioner has not taken steps for issuance of notice upon respondent number 1 and 2, though he was directed to do so by order dated 12/3/2026. It appears that in the connected MAC appeal number 499/2018, Mr. K.K. Nandi has appeared for respondent number 2 and 3 in that case, namely, who are 2 and 3? Manju De
and Pradeep De.
and Pradeep De, who are also respondent number 2, 1 and 2 in the instant interlocutory application. Hence, Mr. De is requested to take instruction from the said respondent as to whether he can appear in this interlocutory application or not. In the meanwhile, the applicant shall take fresh steps for issuance of notice upon the respondents by speed post. Upon all the respondents, there are 3 respondents by speed post. within 7 days from the date of this order, returnable on 29th of May.
Lordship, in item 90, I am for the appellant.
Tim,
20.
Ms. S. Mushari, you are appearing for item in 19,
No, Lordship.
respondent number 3.
We have also to take instruction.
Mrs. Mushari, learned counsel for Oriental Insurance Company Limited, submits that she may also be given some time to take instruction as to whether she can appear for respondent number 3 or not. List accordingly on 2019. In MAC appeal number 20, heard Mrs. Mushari, learned counsel for the appellant, also heard Mr. K.K. Nandi, appearing for respondent number
2 and 3.
2 and 3, as well as Mr.
Really.
A. Ali, appearing for respondent number 1. List this matter again on 29th May, along with MAC appeal number 429/2018.
Lordship, TCR may be called for.
Let the records of 499 of Kiman 1045. The records have arrived. Both the appeals are arising out of same case.
Yes, Lordship.
What is the MSC case number?
Item 20, MSC case number is Lordship 1045 of 2019.
Item 19.
I don't have copy, Lordship.
Yes, sir.
What is the MSC case number in it?
429 of 2018.
MSC case number
429.
429.
Need to appeal.
Then why it has been tagged?
Lordship, sorry, Lordship, 1045, Lordship.
It has, we have received the code.
I do.
Item 21.
I am for the respondent, my lord. Due to some clerical mistake, my lord, instead of respondent in the Wakalandama, appellant has been written, my lord. That's why my name has not been reflected, my lord. Respondent side, my lord.
What is your name?
M.K. Sharma, my lord.
Mr. M.K.
My lord, in fact, this case, my lord, the matter has not been admitted till date, my lord. And in fact, my lord, no notice was issued.
Okay. Then
Without
today,
issuance of notice, my lord, surprisingly, the appellant has taken steps, my lord. I don't know how he has taken the steps, my lord. My lord, may I kindly see order dated 17/3/2021.
but this is a very old pending appeal.
Pending appeal, my lord, main question from the first date arose before this honorable court is that whether the special court as under section 14 of the Land Grabbing Act has been constituted or not, my lord. Because the appellate court is the special court, my lord, as per section 14 of the Land Grabbing Act, my lord.
But now it has been constituted.
My lord, I think the matter is pending before the honorable court, my lord. In a writ petition, it is pending, my lord.
It has,
And the writ petition is still pending, my lord. The next date was not fixed, my lord. It was last listed in the year 2020, my lord. WBC number 1127/2018, my lord. In fact, in one of the order passed by this honorable court, my lord, the case number is also reflected, my lord.
So this appeal is yet to be admitted.
Yet to be admitted, my lord, and notice has not been issued, my lord. Surprisingly, how the appellant has taken step, my lord, I don't know.
None has appeared. Item number? Item number 21. None has appeared for the appellant on call. Mr. M.K. Sharma, learned counsel for respondent number.
Singular, my lord.
Learned
Full
counsel for the respondent has appeared and submits that though the notice he has received the notice in this case, however, it appears that this appeal is yet to be admitted. Stop. I have perused the record. Considering the facts, let this appeal be listed for admission on 8th of May.
Deeply.
Item 26.
Your lordship. Lordship, in this case, service is complete, but LCR has not been received. So rest may be directed to send the reminder for call for the SCR.
Heard Mr. R. Sharma, learned counsel for the appellant. Also heard Mr. D.K. Sharma, learned counsel for respondent. It appears that the service of notice on all parties is complete in this case. However, the records of MAC case number, what is the case?
Yes, my lordship.
MAC case number 1297/2008 has not yet been received from the court of learned additional district judge number 2. Let a reminder be issued to the said court as well as to the Motor Accident Claims Tribunal number 1 Kamrup Metro for sending the records of the MAC case number 1297/2008 to this court without fail before the next date fixed.
Lordship, on last occasion, this honorable court has directed to deposit the 50% of awarded amount.
Whether any stay is there?
Lordship, already in the year 2021, we have deposited the amount.
No, Lordship, as per the last order, they ought to have deposited the 50% of the awarded amount.
No, they are saying that they have already deposited it.
In the year 21, Lordship.
It was not pointed out to the court on last occasion.
Actually, I was not appearing on that day.
Lordship, already on record, I have on.
Lordship, may I kindly see IA number 2196. The stay petition.
Where is the proof of deposit? You go through the record. Order dated?
Order dated, Lordship, 22/2021. In IA 2190, Lordship. 2196.
No, there has to be some.
Lordship, I have the receipt acknowledgement, Lordship. Can you take up for some time, Lordship?
Okay. Learned counsel for the respondent number 1 has pointed out that on last date, that is by order dated 6/3/2026, the insurance company appellant was directed to deposit 50% of the awarded amount before the registry. However, learned counsel for the appellant submits that the appellant has already deposited 50% of the awarded amount in pursuant to the direction of this court in IA Civil number 2196/2020 on 22/2/2021. Stop. Learned counsel for the appellant further submits that he can produce the requisite receipt in proof of his deposit, the money deposited by the insurance company on the next date fixed. The counsel for the both parties are also requested to go through the record to find out is there any endorsement regarding.
In that event, I may be allowed to.
No, you first find out.
Withdraw the 50% of the awarded amount.
No, yesterday, on last occasion, why court passed this order? 50% of the awarded amount. On whose submission this order was made?
Lordship, I have submitted.
Why you submitted without verifying the records?
Lordship, other side, I have not submitted any records that they have submitted already statutory
So
deposit.
like, after this order have verified from the insurance company, and they have said already in the year 2021, on 8th of April 2021, they have deposited the amount.
You submit the receipt on the next date fix. Last line क्या था? Endorsement in the records. You go through the records. There would be some endorsement somewhere. Records regarding deposit of 50% of the awarded amount by the insurance company. Let a reminder be issued to the concerned tribunal for sending the records of MAC case number 1297/2008 without fail to this court before next date fix. Let this case be listed.
This lordship shall be verified. One AP is there in the registry. Now itself it will be verified whether deposition or on the mobile itself, lordship.
Let them verify. We are fixing when? 22nd May.
Lordship, I may be allowed to withdraw the.
You file an application. First verify whether it has been deposited. And then if you find that it has been deposited, you file an application. We will allow.
Lords.
Item 27.
His
Yes.
lordship, on the last date, I have taken the steps and they have received it.
And for the sole respondent.
The appearance is complete.
Yes.
Yes, your lordship. And
The records have this.
no, your lordship, I don't think so. The TCL record has yet been received.
This appeal is against which order?
This is again judgment and decree dated 14 March 2020.
Okay, records would be necessary. Heard, miss. What is your name?
D dash, your lordship.
D.
D dash.
D. Das, learned counsel for the appellant. Also heard Mr.
J. Chopra.
J. Chopra, learned counsel for the sole respondent. It appears that the appearance of both parties is complete in this case. However, the records of the trial court have not yet been received. Stop. Registry to issue reminder for requisitioning the records of money suit number 89/2013. There was some delay.
No, Your Lordship, I've seen.
Means they had filed the appeal and thereafter for a long period of time, it was in objection now.
Okay.
For two to
Records
three-
of money suit number 2089/2013 from the Court of London, Sevilla Senior Division, number 1, Kamrup Metro, before the next date fixed. Let this matter be listed on 22nd of May.
Lordship, one prayer is there, pursuant to Your Honor, Lordship, Order 41, Rule 1, Sub Rule 3, they may be, since it is a money appeal, they may be directed to make some deposit of at least 50% of the decretal amount, Your Lordship.
No, but there is no prayer for stay.
So this deduction is not subject to that prayer. Your Lordship. Order 41, Rule 1, Sub Rule 3.
Yes, you have any submission?
Your Lordship, I haven't got instruction regarding that. So if he wants to do it, then kindly give it as a next day so that my senior could come and argue on this thing. Or he shall give a submission on that matter.
Okay. Learned counsel for the respondent makes a submission that in pursuant to the provisions contained in Order 41, Rule 1, within bracket 3 of the Code of Civil Procedure 1908, the appellant may be allowed to furnish, may be directed to deposit the amount disputed in the appeal or furnish such security in respect thereof as may be directed by this court. Learned counsel for the appellant submits that since this submission has been made for the defendant by the respondent today only, she needs some time to respond to same. The prayer is allowed. Both the parties may make their submissions in respect of the provisions contained in Order 41, Rule 1, within bracket 3 of the Code of Civil Procedure on the next date fixed. Let this matter be listed on 22nd of May. Let the records requisitioner reminder दिया, ठीक है 22nd of May.
Much obliged.
Item 28 and 29.
May please your lordship.
Maybe sorry, Cindy.
Kindly matter may pass about for the day, lordship.
Yes.
My senior mother-in-law expired yesterday, lordship.
Heard Miss
Please, Surya.
P.
P.
P. Sutia, learned counsel for respondent, who submits that the engaged counsel for the respondent is in bereavement, and on that ground an adjournment is prayed for. Also, Mr. D. Burwa, learned counsel for the appellant who does not oppose the prayer, hence the prayer is allowed. Let this matter be listed. 25th of May.
Item 30.
Okay, please, your lordship. As per office note dated 1/4/2026, neither AD nor service report in respect to R2 has been received, lawsuit. Notice has been sent recently, lawsuit. We have to wait it.
Okay, heard Mr. A. Acharya, learned counsel for the appellant. On perusal of office note dated 1/4/2026, it appears that the notice issued to respondent number, why only two?
One has appeared and three is complete, lawsuit. By order dated.
Two has not yet been received back. Stop. The registry is directed to place the postal track consignment report of the notice issued to respondent number 2 by speed post, comma, before this court on the next date fixed. Let this matter be listed. 8th of May.
Lawsuit, I have a prayer. There is an analogous case, MSC appeal number 90/2025. May that also be listed along with this.
Let this appeal be listed on 8th of May 2025, along with MSC appeal number
90/2025.
19/2020.
90. 90. 2025. Okay. Oh, please.
Item 31.
May it please your lordship. Your lordship may peruse office note dated 2/4/2026. Your lordship, in respect of respondent number 4, neither ready card nor answer of notice has been received, your lordship. Notices were issued on 23/2026. Service report may be awaited, your lordship, in respect of.
Ms. P. Thakur, learned counsel for.
Lordships, there is an IA, lordships, regarding 50% of payment, lordships.
Let me pass orders in this case. Then we'll go to I. Heard Ms. P. Thakur, learned counsel for the appellant. Also heard Mr. S.C. Pandit, appearing for respondent number 1, 2, 3, 5, and 6. On perusal of the office note dated 2/4/2026, it appears that the service report in respect of notices issued to respondent number 4 is still awaited. So, the registry is directed to place the postal track consignment report of notice issued to respondent number 4 by speed post before this court on the next date fixed. Let this matter be listed. 15th of May. Where is the IA? Yes, now you may submit.
Lordships, IA 100, lordships, that is for payment of 50% of awarded amount.
Is there any stay application?
Lordship, I has been disposed of, your lordship. There was no direction for any deposit, your lordship, at that stage. Since appeal is not on quantum, your lordship, we have denied employer-employee relationship, your lordship.
Lordships, accident took
So I
place
pray that, your lordship, this appeal can be heard finally, your lordship.
28/3/23. As per paragraph 5 of this IA, the applicants are facing financial hardships after the death of Osman Ali, because he was a sole only member of the family. The family consists of 5 members: father, mother, wife, and 2 children.
The IA has already been disposed of. So on IA for grant of stay filed by the applicant insurance company has been disposed of. So you have to pray for vacating the interim order passed in that IA. Then only you have only filed an application for deposit of 50% of the. There has to be pray for modification, alteration of the order passed in the connected interlocutory application. Then only this can be entertained.
On the other hand, Lordships, though there has been submitted three in law, no? Three law points regarding ownerships and relations of the employer and employee, but there is no such.
No. Not
It
the
may be disposed of early Lordships
the
because
main appeal.
Main appeal also. Lordships.
Okay.
Lordships.
Your Lordship may give a short date, Your Lordship.
Monday,
Short date may be given, Lordships.
15th of May.
Because
15th of May.
though formulated some substantial question of law, but there is no such question. Only verbal statement on the
What is to be done with your IA for 50% deposit? Yes, Ms. Bhattakur. What should we do with this?
Lordship, they have to file an application for modification, Your Lordship, for consideration of this.
Then it is maintainable.
Lordship.
That's maybe I may file that IA also another for modification, but it may be posted for final hearing.
Okay.
Already been LCR
15.
already been written.
Lordship, for that service. must
Yes,
be
we will.
completed about
We
report
will
Number 4, since owner is an.
list on
expert
15th
party,
May. 15th May.
Item
Lordship.
32.
May please, Your Lordship. Kindly allow some time, Lordship,
Yes.
for taking step.
Heard Ms. Peace.
Sukhia.
Suthia, learned counsel for the appellant, who prays for an adjournment on the ground that the conducting counsel for the appellant is in bereavement. The prayer is allowed. Let this matter be listed 25th of May.
Item 33.
By the mistake of our office clerk, my lord, we have not taken steps, my lord, so some time may be needed, my lord.
Heard Ms. L. Sharma, learned counsel for the applicant, who submits that due to some inadvertent mistake, the applicant could not take steps for issuance of notice as was directed by this court by its order dated 21/2/2025. She seeks some more time for taking steps. Prayer is allowed. The applicant shall take steps for service of notice upon
On the response.
respondent number 1 to 7 by speed post as well as by usual mode within a week from the date of this order, returnable on 29th of May.
Item 34. Item number 34.
None has appeared for the applicant on call. List this matter again on 30 April.
Item 35.
Okay, it's in paragraph number 3 and 5, my lord, of order dated number 15/9/2025, my lord, some typographical error is there, my lord. In item number 3, my lord, criminal petition number 1 5/6/2020, it must be 2024, my lord. Instead of 2025, my lord.
Where?
Page number 10, my lord. In IVR,
Line number?
page number 10, my lord, in paragraph 3, my lord. In paragraph 2, it is correctly written, my lord. In paragraph
Only mistake is in paragraph 3.
3, my lord, there, and paragraph 5, my lord. Paragraph 3, my lord, it should be 2024, my lord. 156/2024, my lord.
And paragraph 5?
And paragraph 5, my lord, it should be 2023, my lord. In paragraph 4, it is correctly written, my lord, and paragraph 5 is, my lord, the wrong typographical error, my lord.
So these two mistakes are
Yes,
there.
my lord. And due to that, my lord, the criminal petition, criminal petition is tagged with the file, my lord.
Heard, Mr. What is your name?
HL Oscar, my lord.
H.A. Laskar, learned counsel for the applicant. This interlocutory application has been filed by the petitioner in connection with criminal petition number 1375/2024, praying for rectification of clerical mistake which has been crept in the order dated 15/9/2025, passed in criminal petition number 1375/2024. Learned counsel for the applicant has submitted that in paragraph number 3 of the order dated 15/9/2025, passed in criminal petition number 1375/2024, the criminal petition number 156/2025 is wrongly mentioned. It ought to have been 156/2024. And whereas in paragraph 5 of the said order, Dispur PS case number 1158/2024 has been wrongly mentioned. It ought to have been Dispur PS case number 1158/2023. Sir, I have heard Mr. K.K. Das, learned additional public prosecutor also. On perusal of the records, it appears that the mistake pointed out by learned counsel for the petitioner is inadvertent typographical mistakes, which is required to be corrected. Accordingly, same is corrected. The criminal petition number 156/2025 mentioned in paragraph number 3 of order dated 15/9/2025 in criminal petition number 1375/2024 shall be read as criminal petition number within inverted comma digo, criminal petition number 156/2024 inverted comma close. Similarly, the Dispur PS case number 1158/2024 mentioned in paragraph number 5 of the aforesaid order shall be read as Dispur PS case number within inverted comma digo, Dispur PS case number 1158/2023. This interlocutory application is accordingly disposed of.
My lord, wrong criminal petition is already tagged with the file, my lord. This may be criminal petition number 156/2025, my lord, already tagged with the file.
That is not required now.
Yes, my lord, not required.
That is not required.
Most of them.
Item 46.
Lord, I'm appearing for both the respondents, my lord. I'm seeking some time to file an objection to the
Re-
delay condonation.
Okay. Heard Miss, what is the
N.
name?
Upadhyay, my lord.
No, what's your name?
K. Verma.
Heard Miss K. Verma, learned counsel for the applicant. Also heard Miss L. Upadhyay, appearing for both the respondents, who seeks some time for filing written objection against the prayer for condonation of delay filed by the applicant. The prayer is allowed. The respondent may file their written objection before the next date fixed. Let this matter be listed on 20th of May.
Grateful, my lord.
Item 47.
May I please your lordship, my lord, upon instruction from my client, my lord, appearing on their behalf, but we are yet to file our power, my lord. We'll file our power and objection in this case. 4 weeks time may be allowed.
This is what condonation, delay.
Condonation of delay of 280 days. my lord.
None has appeared for the applicant when the matter was called. Mr.
SK Chakravarti
S.K. Chakravarti,
for the opposite.
learned counsel for how many respondents?
3, my lord.
All the respondents. Learned counsel for the respondents have appeared and submitted that he has been instructed by the respondents to appear in this interlocutory application. He, however, submits that he may be given some time to file wakalatnama in this case. The prayer is allowed. Let this matter be listed
20.
on 20th of May.
Item 41.
May it please your lordship. Your lordship may peruse of this note dated 2/4/2026. Respondent number 1 has filed your wakalatnama, but as regards respondent number 2 and 3, a card is not received, your lordship. Notices were issued on 12/3/2026. So your lordship, service report may be awaited upon 2 and 3.
Heard Miss P. Bhattakur, learned counsel for the appellant. Also heard Mr. K. Bhattacharjee, learned counsel for respondent number 1. On perusal of the office note dated 2/4/2026, it appears that service report in respect of notices issued to respondent number 2 and 3 are awaited. Stop. The registry is directed to place the postal track consignment report of notice issued to respondent number 2 and 3 by speed post before this court on the next date fixed. Let this matter be listed on 20th of May.
Obliged.
43.
It please your lordship.
Yes.
As per the last order, we were directed to issue notice to respondents 2 and 3. And as per the office note dated 2/4/2026, service report of respondent 2 and 3 is awaited.
Heard Miss
Lordship, I am appearing on behalf of the claimant, Lordship.
1.
Lordship, another submission is that, Lordship, they have appeal is admitted and stay petition is pending, Lordship. They have challenged my award basically on the ground that the pay and recovery is no longer exist after amendment of 2019. Lordship, kindly have a look, Lordship. Section 147(4), Lordship, kindly look of MB Act, new amendment Act.
What you want to submit?
Lordship, kindly say. So for my understanding is that, Lordship,
Now that we will consider in appeal.
Lordship.
Appeal is already
that reason,
admitted.
Lordship, we are praying for release of 50%. That's.
Have they prayed for stay?
They have
Is-
filed an application for stay.
Stay application is
Yes,
there.
Lordship.
Whether any order has been passed.
No, Lordship, no order about that. IS bill number 500.
So
Pending.
when we'll consider the stay application, you may make your submissions.
Yes, Lordship. 147(4), Lordship.
Just a minute. appealot লিখিব heard Miss
Sangma,
PK
PC Sangma,
PC Sangma, learned counsel for the appellant. Also heard Mr. A.T. Sarkar, learned counsel for respondent number 1. On perusal of the office note dated 2/4/2026, it appears that notice to respond issued to respondent number 2 and 3 have not yet returned. Stop. The appellant, the registry is directed to place postal track consignment report of notices issued to respondent number 2 and 3 by speed post before this court on the next date fixed. Let this matter be listed 20 May.
So stay petition is pending, lordship. I am praying for lordship. IA may be fixed on lordship.
Okay, you have any submission?
Lordship, I need to take instructions from my senior.
May be fixed on 23rd April, lordship.
Okay, on next date, we'll consider this stay application.
Yes, lordship. On 23 April, next
Even-
date may be fixed, lordship.
20th of
Little late, lordship. So little bit earlier, so his mother, lordship, son expired. And award is lordship only 4,14,000.
April month plus 30 April. In MAC case also 30 April and this also 30 April. What you wanted to point out? 147?
147 lordship, kindly say, my understanding is lordship, different lordship, but kindly have a look. They are correct, lordship, the after 19 amendment, lordship, pay and recovery is no longer exist, but lordship, 147.4.
147?
4.
Yes.
Notwithstanding anything contained in this act, a policy of insurance issued before the commencement of Motor Vehicles Act 2019 shall be continued on the existing terms under the contract, and the provisions of this act shall apply if this act had not been amended by the said act. Lordship, this is here in this case, lordship, insurance policy was covered on 6/4/19 to 5/4/2020. It is much before the amendment, and amendment came into effect on 9th August 2019. So lordship, pay and recovery in this case, so far my humble understanding from this clause, lordship, a section, it is applicable.
Okay, we'll consider on next, on 30 April, when we take up the IA. We'll consider your submission, let them respond to that. Main appeal में IA में लिखना list this matter along with appeal on 30 April.
Item 44. Please, Lord. Actually, as per office note dated 2/4/2026, the service reports upon respondent number 124 are waited, Lord. The notices were issued on 23/2026.
Heard Mr. R. Sharma.
Yes, Sharma.
S. Sharma, learned counsel for the appellant. The office note dated 2/4/2026 shows that the service report in respect of notices issued to all the respondents is awaited. Stop. The registry is directed to place postal track consignment reports of notices issued to respondent number 1, 2, 3, and 4 by speed post. But you have taken steps by usual post. We will never get report.
With AD, Lordship. It was directed by the court that we should take steps by usual post with AD.
No, you take steps by speed post. Take fresh steps. It appears that the petitioners, that the appellant has taken steps for notice of issuance of notice upon the respondent by usual post. The appellant is directed to take fresh steps for issuance of notice by speed post within 7 days from the date of this order, returnable on 25th of May. Yes,
Service will be added on respondent number 4 and 5.
respondent number
4 and 5. 1 to 3.
5,
4 and 5.
1, 2, and 3.
2 and 3.
Okay. So service is complete.
Please complete. LCA has not come. Also. Your Lordship, we have just received the case and we have filed the wakalat nama recently on 2nd of this month.
Okay.
We kindly need some time to file a reply.
What reply? Let the record come. Heard Mr. K.K. Bhatto, learned counsel for the appellant. Also heard Miss
M. Gazlu.
M.
M. Gazlu. For respondent number 1, 2, and 3.
for respondent number 1, 2, and 3.
Yes.
Also heard Mr.
Irajkon.
Your name is M.
M. Gazlu, Your Honor.
G.
ZLOO.
A. O. M. Gazno, learned counsel for respondent number 1, 2, and 3. Also heard Mr.
Irajkon.
A. Rajkwa, appearing for respondent number 4 and 5. The service of notice to all the respondents is complete in this case. However, it appears that the records of MAC case number 2013/2018 has not yet been received from the concerned tribunal. The registry shall issue reminder for the aforesaid records. Let this matter be listed on 28th of May.
Finding item 3.
Lordship, other side is not there, so your Lordship may take it at 2 PM. Other side is.
Okay. At 2 we'll take it.
Item 46.
On number first.
May it please your Lordship. Your Lordship, service report may be awaited upon respondent number 1 and 2.
Heard Miss P. Thakur.
May it please your Lordship. I beg your pardon to interrupt in the middle. I'm appearing for respondent number 1, Your Lordship. I filed the wakalat nama on 4th of April. So my name is not there in the cause list.
What is your name?
Miss Abora.
Heard Miss P. Thakur, learned counsel for the appellant. Why this interlocutory application for delay?
Delay, Lordship.
Learned counsel for the applicant. Also heard Miss A. Bora, learned counsel for respondent number 1. It appears that the notice issued to respondent number 2, there are 2 respondents only. 2 has not yet returned. The registry is directed to no, but you took steps for issuance of notice by Dusty mode.
Lordship, both by usual as well as by Dusty, Your Lordship. As regards Dusty, Your Lordship, Dusty report is awaited, Your Lordship.
Okay.
In respect of respondent number 2.
Counsel for the applicant submits that she may be given some time to file affidavit in compliance as regards service of notice on respondent number 2 by Dusty mode. The prayer is allowed. Let this matter be listed on 20th of May. The registry is directed to reflect the name of Miss A. Bora as engaged counsel for respondent number 1 in the cause list henceforth.
Obeyed.
Item 47.
Lordship, the conducting counsel, he is tied up in a special fast track court, so let the matter be fixed. The CC hearing is going on there.
Why this interlocutory application is for?
This for release of the deposited amount of rupees 5 lakhs.
By furnishing bond, they will be allowed.
Okay.
Let this matter be
What
fixed.
is your name?
D doctor.
Heard Mr. D. Datta, learned counsel for the applicant. This also heard Mr. K. K. Bhatta, learned counsel for the insurance company. This interlocutory application has been filed by the applicant / claimants for allowing the applicant / claimants to withdraw the amount of rupees 5 lakhs which was deposited by the respondent insurance company in pursuant to the directions of this court by order dated 22/9/2025 passed in IA civil number 3128/2025 in connection with MAC appeal number 441/2025. Mr. K. K. Bhatta, learned counsel for the insurance company, raised no objection. However, he submits that while releasing the aforesaid amount, the applicants may be directed to submit indemnity bonds. Hence, the prayer is allowed. The registry is directed to release the amount of rupees 5 lakh which was deposited by the insurance company before it in pursuant to the order dated 22/9/2025 passed in IA civil number 3128/2025 to the claimants applicant, namely Raju Deka Borua and Pabitra. What is the name? Pabitra Deka Borua on furnishing of indemnity bond to the tune of rupees 5 lakhs. This interlocutory application is accordingly disposed of.
Regarding main appeal, Lordship, name of the respondent number 4 and 5 may be strike out, Lordship.
Main appeal. Heard Mr. K. K. Bhatta, learned counsel for the appellant. Also heard Mr.
D doctor.
D. Datta, appearing for respondent number
1 and 2.
1 and 2. As regards 3, what happened?
Lordship,
3.
Lordship, 3 and 4, I want to. 1, 2,
How many respondents are there?
4 respondents, Lordship. 4 respondents.
4 respondents.
1 and 2.
Name of the respondent. 3
Learned counsel for the appellant submits that since you are
against the.
since the appellant is aggrieved mainly with the quantum of compensation awarded to the claimant, the necessity of respondent number 4 and 3 and 4 may not be there in this appeal for consideration of this appeal. Hence, he prays for waiving the notice to them. The prayer is allowed. Accordingly, notice to appellant number 3 and respondent number 3 and 4 is hereby waived. Record this. Release this matter for hearing on 16th of July.
Next item is mine, Lordship. He has come, so Only thing we have taken steps on only fourth lordship. So it'll be
Item number,
48, next item.
heard Ms. R.D. Majumdar, learned counsel for the appellant. Also heard Mr. A.R. Agarwala.
No, no,
learned-
He is not there.
I will put in.
We have taken step, just taken step on for this is taken step on for fourth lordship. Maybe the office notice that we have not taken step, but we have taken step.
Oh, the office note reflects that the applicant has not taken steps for issuance of notice. However, learned counsel for the applicant submits that the applicant has taken steps for issuance of notice
On fourth.
on 4th of April. Stop. Accordingly, let the postal track consignment of notices issued to respondent by speed post be placed before this court on the next date fixed, that is 20th of May.
Really obliged, Lordship.
You have to wait.
Item 49.
May I please be made, Lord? Lordship, this IA is filed for correction of the local auth order, Lordship. There is slight mistake in the local auth order, Lordship. Order is in page number 8, Lordship. Here, Lordship, rupees 10 lakhs has been fixed deposit in the name of the nationalized bank. But in the whom name and for how many years that is deposited, that is not mentioned, Lordship. And again, balance amount is to be done by the respondent number 1, Lordship, wife of the deceased, Lordship.
Who passed the order?
Justice Lordship Pranjal Das.
It should go to the same bench.
But Lordship, I mentioned that Lordship, that connected
What rectification you are seeking?
that respond number 10 lakhs rupees, Lordship, that is to be divided among the for the claimants fixed deposit. And balance amount may kindly be allowed to withdraw by respond number 1, Lordship, wife of the deceased.
No, it should go to the same bench. Heard. Mr. A.R. Agarwala, learned counsel for the applicant. This interlocutory application has been filed by the insurance company,
Yes, Lordship.
applicant insurance company.
No,
Or
myself is claimant, Lordship. Respondent
applicant,
claim.
applicant,
Respondent claimants.
who has filed this application?
I filed, Lordship, respondent claimant, Lordship.
Applicants slash claimant for correction of order dated 13/9/2025 passed by the Lok Adalat within bracket by Honorable Mr. Justice Pranjal Das in MSc appeal number in IA number IA within bracket civil number 2210/2024. Stop. Also Mr. T. Kolitali. Since this, since the correction sought for by the applicant does not appear to be a typographical or clerical mistake, this court is of considered opinion that this application is to be placed before the concerned judge who has passed the aforesaid order. Accordingly, registry shall list this matter before the appropriate bench.
Lordship, on the 8th, Lordship, if
No,
before view, they will get the. On 8th, Wednesday, Lordship, last court. Before view.
on
8 only.
8th of April,
Yes, Lord.
2020.
Before view, they can get the money.
List accordingly.
Much of this, Lordship.
Much.
Item 52.
May it please your lordship. Your lordship, may peruse office note dated 4/4/2026. Your lordship, in respect of respondent number 2, no response has been received, your lordship. Notices were issued on 25/3/2026, your lordship. So it should be
Respondent number 1 is appearing. You are for 2? Okay,
completed.
okay, heard Miss P. Thakur, learned counsel for the appellant. Also heard Mr.
A. Hussain, Lordship.
A. Hussain appearing for respondent number 1, as well as Mr.
A Borman.
A. Burman appearing for respondent number 2. Records I said.
And series not here, your lordship.
The appearance of parties in this appeal is complete. However, it appears that records of which case?
WC case number 7/2025, Bongaigaon, your lordship.
Records of WC case number 7/2015 has not yet been received. Issue reminder for the same registry to issue reminder. Let this matter be listed on 20 May.
Obliged, your lordship.
Item 3.
May it please your lordship. This is an appeal under section 47 of the Guardians and Wards Act, Lord. An application was filed by the father of the child before the family court in Dhubri, Lordship, which was numbered as Miss G case number 8/2022, annexure 3, page 20.
47 is the appellate provision.
Yes, Lordship.
Your application was filed under what provision?
Here it was filed under 7 and later on 25 was also added under Guardians and Wards Act.
Okay. Where is the impugn order?
Second, the father seeks custody of the child, that is prayer portion is page 24 before going to the impugn order, Lordship. Under the above facts and circumstances, it is therefore prayed that your honor would be pleased enough to pass an order directing the OP number 1 and 2, maternal grandfather and grandfather, to hand over the custody of the baby to the petitioner for the ends of justice. In this case, what happened, Lordship, there were lots of cases between husband and wife, and thereafter a mutual agreement took place, where father handed over the child to the mother to look after the child by the mother, Lordship. But after that mutual agreement, the mother remarried to a third person, Lordship. So thereafter he filed this petition, praying custody of the child from grandfather and grandmother. That was contested by both the grandfather and grandmother, and it is an admitted case. Mother was remarried. Annexure, Lordship, page 33 is the impugn order, annexure 5. 29/6/2024.
And point for determination, page 37.
How old is child?
Child is at present 8 years.
8 years.
Yes, Lordship. His date of birth is. Kiman? 27/9/2017. Mutual agreement took place on 24/8/2020.
Yes.
Page 37, second paragraph, your lordship will find paragraph 4. The effort for reconciliation settlement between the parties was duly made by sending the case to the learned counselor, but it failed due to absence of the opposite parties. Thereafter, paragraph 5, the petitioner during hearing adduced evidence on affidavit by examining himself as PW1 and 2 other witnesses, namely Inamul Haq and Shahanur Haq, as PW2 and PW3 respectively. However, the cross-examination of the petitioner witness and thereafter the evidence of the opposite parties stood closed in view of the repeated absence of the opposite.
It proceeded ex parte.
Yes, Lordship. They remained absent thereafter. Written statement they filed. I have enclosed the written statement also. Page 25.
Thereafter,
Then the petitioner could not be heard after the closure of the evidence earlier or today, as he is found absent on call today. Peruse the case record. Point for determination. Whether the petitioner, being the father of the minor child, is entitled to get his custody. What is the best interest of the child in this case? Paragraph 8. It is evident from the plain reading of section 25 of the Act, under which the instant petition is stated to be filed instead of section 7 of the Act, as revealed from order dated 3/6/2024 and 19/6/2024 in the instant case, that the sole opinion to be held by the court under the provision being invoked by the petitioner to secure the relevant relief in the instant case is that it is welfare of the minor ward child which requires the child to be returned to the custody of his guardian.
what is 25 of the Act? Guardianship. And what is there in 7?
Section 25, title of guardian to custody of ward. If a ward leaves or is removed from the custody of a guardian of his person, the court, if it is of opinion that it will be for the welfare of the ward to return to the custody of his guardian, may make an order for his return, and for the purpose of enforcing the order may cause the ward to be arrested and to be delivered into the custody of the guardian. For the purpose of arresting the ward, the court may exercise the power conferred on a magistrate of the first class by section 100 of the Code of Criminal Procedure. The residence of a ward against the will of his guardian with a person who is not his guardian does not of itself terminate the guardianship. The parties are governed by Mohammedan law, Lordship. The Mohammedan law itself says that for appointing guardian, the provisions of guardians and wards law will be applicable.
But guardian has to be appointed under section 7 only.
7, the petition was filed under 7 and thereafter 25 was included.
Okay.
As per section 349 of guardianship of person and property under Mohammedan law, it says all applications for the appointment of a guardian of the person or property or both of a minor are to be made under the Guardians and Wards Act 1890. So the application which was filed, it is maintainable.
Okay.
Section 7, Lordship, that is power of the court to make order as to guardianship. Where the court is satisfied that it is.
This appeal is yet to be admitted.
Lordship can dispose it of.
Today it said.
My lord.
Otherwise, my lord, in
Notice
this,
issue,
my lord,
Your Lordship.
include judgment, my lord, nothing has to interference. Reasonable order has been passed. And my lord, whatever,
Okay, let her complete.
my,
In this case, what happened, Lordship, when he applied, the child was below the age of 7 years. And as per Mohammedan law, up to age of 7 years, if it's a boy child, Lordship, then mother is the natural guardian.
Okay.
As per section 352, right of mother to custody of infant children under Mohammedan law.
Mohammedan law, there cannot be any section.
Lordship, that is, normally it is written as section, but there cannot be any section, Lordship. It is on the basis of Quran. But this book, just to read the,
Quran or other source of Mohammedan law,
yes,
like Hadith.
hadith and all this, Lordship. So normally to say what is the section, normally we write section 352, Lordship. So it says right of mother to custody of infant children. The mother is entitled to the custody, hizanat, of her male child until he has completed the age of 7 years, and of her female child until she has attained puberty. The right continues though she is divorced by the father of the child, unless she marries a second husband, in which case the custody belongs to the father.
But Guardianship and Wards Act is applicable.
Welfare will come now.
Yes.
Mohammedan law also says to be looked into the welfare of the child. But normally, Lordship, as per Mohammedan law, father is the natural guardian. Till age 7, she is entitled, she is the natural guardian, but as soon as she remarries, father will become natural guardian.
Now the wishes of the child is also relevant.
Lordship, now he is aged about 8 years.
8. He
Almost
can
8.
convey his.
Lordship. So my humble prayer before your Lordship, as the petition was filed at the age of 3.5 years, maybe at that time, and thereafter order was passed. When the order was passed, then the child was the age of 6 years. 6 years. When the family court passed the order, the child was almost 6 years. So my humble prayer before your Lordship to remand it back to consider the case of the petitioner, again by calling the child or by looking into the welfare of the child, as because the opposite party were also absent, petitioner was also absent on the date of hearing, and no PWs was cross-examined. The opposite parties has also not adduced any evidence. So there is no evidence whether the child will be betterly looked into.
How the trial court decided
Trial
not
court
to give you.
decided on the basis of that mutual agreement.
Why discarded the evidence?
Lordship, page 38, I'll read. Paragraph 8. It is evident from the plain reading of section 25 of the Act, under which the instant petition is stated to be filed, instead of section 7 of the Act, so and so, under held by the court, under the provision being invoked by the petitioner to secure the relief in the instant case, is that it is welfare of the minor ward child which requires the child to be returned to the custody of his guardian petitioner. So case of the petitioner is that as mother is no more there in the house, so the grandfather and grandmother are not capable of being looked into the child. So welfare of the child will be best to if the custody is given to the father. Paragraph 9. Thus, the aforesaid provision seeks substantial material on record in favor of the petitioner, showing that welfare of the minor lies in him being in the custody or restored to the custody of the petitioner. Unless such materials are available on record, the relief cannot be extended to the petitioner. Admittedly, the minor child had been in the custody of the opposite party number 3, while the marriage of the petitioner with the opposite party number 3 stood dissolved in the year 2020 by mutual consent, and since then, that is the year 2020, the child is not in the custody of the petitioner. It is alleged that after few days of the dissolution of his marriage, the opposite party number 3 remarried, leaving the child in the custody of her parents. that is the opposite party numbers 1 and 2, it appears that the petitioner has filed the present petition in the year 2023, that is after 3 years of the minor child being not in his custody. But the petitioner has failed to explain that why till the filing of the present petition he did not seek the custody of the child. Furthermore, even after being in knowledge of the remarriage of the opposite party number 3, no such relief appears to have been sought. Further, the contention of the opposite parties in their written objection reveals that the minor is staying with them with the consent of the petitioner. It appears that opposite parties categorically contended that the petitioner at the time of his divorce with the opposite party number 3 by mutual consent agreed that their child would stay in the house of the opposite party number 1 and 2 till attaining the age of 18 years. This finding is wrong. I have gone through the mutual agreement. There was no such statement. The aforesaid fact of agreement by the petitioner or relinquishment of his right to seek custody of his aforesaid minor child has nowhere been disputed, challenged, or denied by the petitioner in his evidence. The pleadings of the opposite parties do not speak well about the antecedents and character conduct of the petitioner either. It reveals that criminal case being instituted by the opposite party number 3 against the petitioner is pending for adjudication. It is contended that the opposite party is a drug addict and a drunkard. There is no denial regarding the pendency of criminal case against him. No effort either has been made to rebut the allegations of being a drunkard and a drug addict. It is further pertinent to mention that admittedly the child, since while being a breastfeeding baby, is not in the custody of the petitioner. There is nothing either on the record showing that during this period the child had any opportunity to stay with the petitioner or any such effort was ever made by the petitioner. Nothing has been brought by the petitioner either revealing that the child has any affinity with him or ever expressed any desire to stay with him. There is no dispute or denial that the child is admitted in school. The fact of financial capability of the opposite parties to take care of the child, as alleged, has also not been disputed. The materials facts as discussed above nowhere speaks anything in favor of the petitioner and thereby does not show that the best interest of the child lies in him being in the custody of the petitioner. But otherwise, hence this court is of the opinion that the custody of the child needs no interference. However, the petitioner being the natural biological father of the minor child shall continue to visit the minor child, provided such visit takes place in a pleasant situation conducive to the well-being of the child. The opposite parties shall ensure that whenever the child desires or expresses his desire to meet his father, they arrange such meeting after mutual consultation with the petitioner.
The order appears to be reasonable.
But Lordship, only plain petition and thereafter written statement, there are PW 1 and 2. They have not cross-examined. So my evidence in total, Lordship, remained. There was no denial from the side of the opposite party number 1 and 2 with evidence. Only pleadings in their written statement. There allegation that I am the Lordship drunken person, but there was no evidence. We have to look into the welfare of the child. The grandfather, grandmother, they are aged person. The child is only 8 years old.
But he's there since.
Yes, sir.
Since his birth.
We can take his consent also by, or Lordship may send this matter to High Court mediation. Both parties are directing to come to the mediation center.
No, whether both parties will appear before Gauhati, are in a position to appear
Yes, if your Lordship
before this court. Because they have not appeared even before family court at Dhubri. So there must be some difficulty.
High Court mediation center, Lordship, there is a chance of mediation between both the parties.
No, if they appear, we can invoke 32, order 32A.
Yes, Lordship. If your Lordship direct, they will appear.
No, you can appear, but whether the grandfather, grandmother.
Friend will try to bring them to Honorable High Court.
I will try.
They can appear.
No, we have not taken yet consent. So we'll try to convince if.
So inform us If they appear, why before mediation center? Let them appear before the
Let them
court
in person.
in
Yes,
camera.
Yes,
Yes.
Then
that will be better.
No, otherwise, my lord, just I am interfering, I'm sorry for that. But otherwise, my lord, character of the father, it's not good. And Honorable learned court is already
no,
recorded. lordship.
this is a family matter.
Yes, my lord,
So without
my lord,
harming the reputation of father,
yes.
we can resolve this issue. At least we can try to resolve this issue.
Lordship.
Better adjudication of the matter, the presence of the father and grandfather is also necessary. And
Yes.
grandfather is aged about 58 years in the year when he filed the written statement. And in the written statement also paragraph 21, the father write that OP number 1 is a businessman having landed property and sufficient income and having full capacity to maintaining of the child in all corners for future.
When can they appear?
Lordship. We have
After
to talk
Bihu,
to
your
them.
lordship may fix it.
After Bihu.
Due
No.
to election, no one will come by this time.
Okay. Heard. Miss R. Chaudhary, learned counsel for the appellant. Also heard Mr. K. K. Rahman,
Yes.
learned counsel for the respondent. This appeal under section 47 of the Guardianship and Wards Act 1890 has been filed by the appellant Abdul Munaf, impugning the order dated 29/6/2024 passed by the principal judge, passed by the learned principal judge, Family Court Dhubri in FC Miss within bracket G case number 8/2023, whereby the application filed by the present appellant under section 7 and section 25 of the Guardianship and Wards Act
Of the
1890, seeking custody of his minor son, was rejected. Learned counsel for the appellant has submitted that though the opposite party number 1 and 2, who are the grandparents, maternal grandparents of the minor son of the appellant, after filing written statement in the aforesaid misguardianship case, did not appear before the family court Dhubri in aforesaid case, and though the appellant adduced evidence of 3 witnesses, same was not taken into consideration while dismissing the petition filed by the present appellant. She further submits that there is no indication in the record that the wishes of the child of the appellant was ever ascertained by the family court, Dhubri, before passing of the impugn order. She submits that since after filing of the written statement, the respondents number 1 and 2 did not appear before the family court. And since this matter pertains to guardianship of a minor, guardianship of the minor son of the appellant, and hence the prime consideration in considering the instant appeal would be the welfare of the child in question. Hence, she submits that, and this court may make an effort for an amicable settlement between the parties in presence of both the parties. She submits that in alternative, this matter may be referred to mediation also. On the other hand, Mr. K. Rahman, learned counsel for the respondents number, all the respondents has submitted that the impugned order passed by the family court is a reasonable order and same need not to be interfered with. However, he agrees that since there is no indication that the respondents ever appeared before the family court or even the wishes of child were ascertained by the family court before passing the order, an effort may be made by this court for amicable settlement between the parties. Stop. Since the parties in this case are related to each related, and this is a matter order 32A. What is 32A? This is a matter concerning the family as well as a family of the minor children, minor son of the appellant. And since this court is of considered opinion that the considering the nature and circumstances of this cause of this case, an effort may be made by this court under order 32 capital A within bracket order 32 capital A rule 3 to make an effort for amicable settlement of the dispute relating to guardianship of the minor son between the parties. Accordingly, both the parties are hereby directed to appear before this court in person at 1:15 p.m. on May 13 तारीख दियो আগত দিব পাৰে
First week of May, Lordship, any date?
yes
On fourth,
First week difficult,
fourth May. no?
second week.
11th of May, Lordship, it will be a
Yes,
Monday.
11th of May
Matter may be kept as part heard, Lordship.
11th of May before this court. Let this matter be listed on 11th of May as Parted matter.
Lordship. And my only one submission, Lordship, welfare of the child was also not taken into consideration, looking into the age of the opposite parties.
Okay, let them come. Let us see how
Yes.
they appear.
Lordship.
Because
As because he is almost 60 years, Lordship, at the time of filing the written statement, and child is of only 6 years at that relevant point of time.
The matter is, my lord, where the child is feeling comfort. That is the things, my lord.
yes,
We'll look after his education, Lordship.
you can look after education.
Lordship, I was always ready to give him assistance, Lordship, and accordingly, the petitioner was already given as Lordship. monetary
You
help.
may continue to assist the child.
Yes, Lordship,
E-
I'm ready,
Even if he remains with
Lordship.
let us interact with them on
Yes,
that
ma'am.
day.
Yes, Lordship. By this time, Lordship, child has developed a bond with his
With
grandparents.
grandparents, so
Yes, Lordship. That I
may,
admit,
it
Lordship.
may be difficult to separate them now, but
Lordship.
let us see
Yes, ma'am.
how it
bless
can
you.
be resolved.
Yes.
Yes.
Item 16.
Yes, Mr. Rahman.
May it please Lordship. On the last day, 2 occasions, I have given my submission, and 3 grounds were taken from me by
Now, where is the,
illegal detention and CDR without 65P certificate and bank transaction, Lordship. And I submitted the judgments in support of my
what were the grounds?
illegal detention. First one was illegal detention, Lordship.
Other grounds are not very strong grounds.
CDR also, Lordship.
CD.
CDR without 665P and
No,
bank tran-
that cannot be considered at, that will be considered at in the trial stage. The reliability of the evidence,
Yes, Lordship.
whether it is reliable or not, that has to be considered by the trial court. But whether there are materials
Lordship.
regarding
Illegal
illegal detention.
Yes, Lordship. Illegal detention, that is, I was apprehended on,
But where is Miss other side? Other side.
I don't know, other side was there, but in this one.
No, somebody কোনোবা এজন থাকিব লাগিছিল. What is to be done?
Lordship, mechanic after some time, I will wait. They want to postpone the case because 2 days already taken for filing written objection, but they have not filed yet, Lordship. Already 1 month has gone in the name of my written objection. Actually, they don't have anything to object, Lordship, but just they are passing the time, consuming the time on it.
You have not filed written objection
No, no, Lordship.
today also.
Yes, Lordship. After some time, I will wait here.
Or we'll take it tomorrow at 2. Yes, he's there.
Yes, Lordship.
Yes.
Ah,
You have not filed written.
I have not filed. In fact, I was to file my affidavit today. I received it on last Thursday. My friend does not want to receive the copy, so I have not been able to file. If my friends receive the copy, let it be day after tomorrow, Lordship. He has not.
Your affidavit is ready.
It's ready. They went to serve him. He refused.
Where? Today
Yes,
also?
Yes,
Today?
yes.
So why? You're supposed to
Lordship,
have been
that's-
before on
I-
before this
Lordship,
date.
At least
On that,
I have put in 29 years of my practice. I have not seen a submission like this. I could very well have handed over a copy to you.
No, you could have received it at least.
Lordship,
Then I could have.
It
given
was-
issue
I was
copy.
not called. My junior was called. He told that I will take it in the court. I was in the court number 25. They called,
Let
I
him
think,
receive it
I think they called me in the,
And I
at
assure,
12 PM.
assure my friend, he will not be prejudiced. Everything is in his favor, but at least he has to receive the copy.
Yes, heard Mr. M. Rahman, learned counsel for the petitioner. Also heard Mr. R.K. Dev Chaudhary, learned Deputy Solicitor General of India, who submits that the written objection to be filed by the NCB is ready and the copy of same was furnished to the learned counsel for the petitioner. However, same was not received and therefore it could not be filed. He submits that if same the copies as he submits that since the written objection is ready, the respondent may be allowed to file the same. Stop. The prayer is allowed. Let a advance copy of the written objection be furnished to the learned counsel for the respondent today itself.
Yes.
Let this matter be listed
Day after tomorrow.
day after tomorrow,
Yes.
8th of May, 8th of April.
Obliged.